DACA Dreamers moving forward, this is immigration attorney Parviz Malakouti, and one question that I see from time to time on the DACA groups, on the interwebs, on the Googles and the Facebooks is what happens if a DACA recipient is charged with a misdemeanor or a felony but not convicted yet, and the DACA recipient wants to apply to renew DACA. Can that DACA recipient apply to renew? It's a good question. It's one I'm going to answer in this video. So first of all, backing up for a quick second, just a review. If you remember, as a general matter, a DACA recipient who has been charged and convicted with a felony, a significant misdemeanor, or 3 or more misdemeanors is not eligible to renew DACA. Now, what is a significant misdemeanor? I can't go over all of the significant misdemeanors for the purposes of this rule in one video, but as a general matter, most of the time it's going to be a DUI, domestic violence conviction, or another drug-related conviction. So getting back to the question, if a DACA recipient is charged with a misdemeanor or a felony and wants to renew, what's going to happen? And the answer is that most of the time the DACA recipient is going to get a request for evidence if they apply to renew DACA and they still have charges pending. If you recall, when you apply for DACA, when you apply to renew DACA, you have to disclose any arrests or charges, regardless of whether they've resulted in a conviction or not. You must disclose those. It's asked for on the application. It's very, very important. So when that is disclosed on the application to renew DACA, USCIS is likely going to send a request for evidence that's going to ask you what was the disposition of that criminal charge. Other than that, it's probably likely that a case is going to be denied before it would be approved with a charge pending that has not been adjudicated yet. Now, one other important thing to remember, how USCIS responds to this could depend on what type of charge it is. If you've been charged with a non-significant misdemeanor, a very, very small case, something that is not anywhere in the realm of being a significant misdemeanor, it's possible that USCIS could approve that DACA application while the charge is still pending. But most likely you're going to get an RFE, a request for evidence, and if you're not able to respond during that time because the case is still pending, you'll probably get a denial. So what do? Very, very important. I've said this before in other videos and I'm going to say it again. If you're a DACA recipient and you're dealing with a criminal charge, any misdemeanor or felony charge, you must get an immigration attorney involved right away. Don't think you're going to handle the criminal case and then go to an immigration attorney. It's very important that the immigration attorney be involved in the negotiations with the criminal defense attorney, with the prosecutor for a plea bargain, because the immigration attorney is going to be able to tell you and coordinate with the criminal attorney about what the possible effects, the immigration impact of those convictions or different pleas are going to be. So it's really important to get the immigration attorney involved while they can still do something to help and influence that plea rather than after the fact. So that's it. I hope this video helps. If you are a DACA recipient or a dreamer and you're not in my Facebook group, DACA Dreamers Moving Forward, you definitely want to join that group. We talk about all these subjects. We talk about news, strategies, immigration tips, etc., etc. The group is open to all DACA recipients and dreamers. Just make sure to answer all 3 questions. That's it. Good luck.